At this time, I'll go ahead and get started to introduce our panelists today. So from our Neighborhood Council Advice Division, we have Elise Rudin, who is the Managing Deputy City Attorney in the Neighborhood Council Advice Division. She joined the unit in 2017. Prior to joining NCAD, Elise served as a prosecutor in the Central Trials Criminal Division, and thereafter she was assigned to the City Attorney's Environmental Justice and Protection Unit, where she prosecuted environmental crimes and litigated unfair business practices, civil enforcement actions against Fortune 500 companies. She is the regional attorney for the entire San Fernando Valley. That's regions 1 through 4. Next, we have Steve Houchin. He is a deputy city attorney with the City Attorney's Neighborhood Council Advice Division. Steve joined the City Attorney's Office in 2014 and previously served as a neighborhood prosecutor assigned to LAPD's Olympic and Hollywood divisions, where he worked to solve quality of life issues, including narcotic crimes, gang activity, and illegal dumping. Prior to the City Attorney's Office, Steve worked as a civil litigator and deputy district attorney in Ventura County. He is currently the assigned regional attorney for neighborhood councils in the West, Central, and Harbor areas. And last but not least, we have City Attorney Ruth Kwan. She is a deputy city attorney with the City Attorney's Neighborhood Council Advice Division. Ruth also represents the city in complex litigation. She joined the City Attorney's Office in 2017 as a litigator for the Business and Complex Litigation Division. Prior to joining the City Attorney's Office, Ruth served as an assistant United States attorney for the Central District of California, handling a variety of civil litigation matters on behalf of the federal government. Ruth started her legal career in the San Francisco office of ORIC, where she was a managing associate. Ruth is a regional attorney for the neighborhood councils located in Region 7, 8, 9, 10, as well as Los Felix, North Westwood, South Robinson, and Studio City neighborhood councils. So thank you all for being here, and I'll go ahead and pass this presentation on to you. Thank you.
Good morning, everybody. Thank you for joining. I'm Elise Rudin. I'm the managing attorney for the NCAD unit. And thank you for being here again. I want to just start off by saying that this is just going to be an overview. This is a very condensed overview of legal issues. We don't expect you to know everything that's involved in these legal issues after this presentation. We just want you, if nothing else comes out of this, it's just to recognize these issues and to know that you can contact your NEA with Dunn, and they can engage us in the NCAD unit, we in the NCAD unit, to try to get more detailed and focused on some of the issues that you may have if you have questions about Brown Act or California Public Records Act, and also conflict of interest. We're here to try to help maneuver through all of those issues. So let's start off, as Vanessa said, our division, each of us are assigned, there's only 3 of us, and each of us are assigned 2 different neighborhood councils. I am with the San Fernando Valley. I represent the San Fernando Valley neighborhood councils, except for Porter Ranch and Studio City. That's regions 1, 2, 3, and 4. Steve Houchin represents regions 5, 6, 11, and 12. And as stated, Ruth represents regions 7, 8, 9, and 10. And also, we will periodically update those assignments and try to get those published to you. Next slide, please. So we're all going to cover different things today. I'm going to start off with just briefly going over the roles of neighborhood councils. Ruth is going to talk about the Brown Act. I'm going to then give an overview of the Public Records Act. And Steve will talk about conflict of interest, which is complex, but we're going to just give you a brief overview, as I stated. Next slide, please. Vanessa, next slide. Thank you. So in general, the role of neighborhood councils is, talked about in the charter, section 900, to promote more citizen participation in government, make government more responsive to local needs. A citywide system of neighborhood councils and a Department of Neighborhood Empowerment is created. That's done. And the neighborhood council shall include representatives of the many diverse interests and communities and shall have an advisory role on issues of concern to the neighborhood. I mean, there's a few things that I'd want to emphasize very briefly on this. First of all, underlining the many diverse interests of the communities. There are going to be people with all different viewpoints, and all of those viewpoints should be represented in some way, or at least listened to by the neighborhood councils. Also, remember the goal is to be responsible to the local needs, be responsible to your community. And those are things to just keep your eye on the ball. You're there to represent your community and to try to get the most done for them as well. Next slide. So example of roles is to present to the mayor and council a list of priorities for the budget. That's under Charter Section 909. To monitor the delivery of city services in the respective areas. 910. Have meetings with city officials. That's 910. Provide input to the city council committees, city boards or commissions before decisions are made. You do those with CIO, community impact statements. That's one way to do it. You could do it in other ways. Neighborhood councils may spend monies for their operations and on neighborhood improvement projects. That's often done through NPGs. And neighborhood councils may provide grants of monies to nonprofits. That's the NPGs as well. Or you could also contract for neighborhood improvement projects. Next slide. So no person, this is important to know. As a member, an individual board member of the neighborhood councils, you serve an important role and your input is very important. However, in representing the neighborhood council as a whole, you should make sure that the board approves whatever role you're going to have if you speak on behalf of the council. So this is also to say that even though you're a member of the committee, committees are advisory to the board. Committee members cannot go and take public positions unless the board approves the committee member to do so, or the committee itself. Individuals may not speak on behalf of the board without board approval, same concept. And board approval is a vote by the board, just so you know, in a number that reflects bylaw requirement for taking actions. So in each of your bylaws, they'll talk about a quorum, they'll talk about how many members need to vote in order to take action. Next slide. Okay, here we are. Ruth is going to now go over the Brown Act.
Good morning, everyone. It's time to talk about the Brown Act, a law that many of you may already be familiar with. But if there is any area of law that embodies Congress's theme of leading change together, it is the Brown Act. Just since March 2020, we've had a social media amendment, a few governor's executive orders regarding the Brown Act, and just last week, a legislative amendment passed regarding the future of teleconferencing meetings. So to the credit of the neighborhood council system, and the neighborhood councils with the assistance of the department and the Board of Neighborhood Commissioners, I want to say that the neighborhood councils have very much risen to the occasion of holding virtual meetings and continuing to engage their communities during the pandemic. So thank you. So what is the Brown Act? The California state law codified in the government code. It applies to certified neighborhood council boards and committees. So both the boards and the committees are legislative bodies under the Brown Act. The Brown Act establishes rules designed to ensure that actions of public bodies are taken openly and with public access and input. So when reading the Brown Act, an important part is to understand what constitutes a meeting, because all the rights and obligations kick in when a meeting under the Brown Act occurs. Next slide, please. What is a meeting? The meeting means any congregation of a majority of members at the same time and location to hear, discuss, deliberate, or take action on any item that is within the subject matter jurisdiction of the neighborhood council. Note first that it is to hear, discuss, deliberate, or take action, any of those things. Note also that it says in the Brown Act at the same time and location. However, we will point out later that it's not always so simple. Think serial meetings. Finally, majority of members. That's been interpreted to mean the least number who can take official action on behalf of the legislative body, whether it's a board or a committee. So for many neighborhood councils, that means a number as low as the majority of your quorum for a board or a majority of the quorum for a specific committee. Many of the prohibitions about meetings are not distinctly delineated. Rather, they fall under the Act's definition of a meeting. So next slide. So within that section of the Brown Act where meeting is defined, there's some additional language that clarifies what is prohibited and not under the Brown Act. Communications do not have to occur in person despite the plain language of the Brown Act. For example, all board emails where discussion is occurring is prohibited because the Brown Act says that communications of any kind cannot discuss, deliberate, or take action. Serial meetings are also problematic. Now, what is a serial meeting for those of you who do not know? There's a provision in the Brown Act's definition of a meeting that says that a majority cannot use a series of communications of any kind directly or through intermediaries to discuss, deliberate, or take action. Serial meetings are usually seen as daisy chain meetings or hub and spoke meetings. Those are all prohibited. In a daisy chain meeting, board member A has a conversation with board member B then has a conversation with C, and so forth, until a majority of the board has discussed, deliberated, or come to some collective decision. That's problematic under the Brown Act. Notably, it's not all happening at the same time or place. A hub and spoke, on the other hand, is a different kind of serial meeting when one person becomes the intermediary. Let's say the president contacts board member A, then the president contacts board member B, then the president contacts board member C, until again, a majority of the board has discussed, deliberated, or come to some collective decision and understanding between all of those board members. So even though those deliberations are not happening at the same time or location, they are expressly prohibited by the Brown Act. Last bullet point is sometimes committee meetings can become problematic. Let's say the executive committee, which pursuant to the bylaws is a standing committee, is holding a meeting. It's properly noticed as an executive committee meeting, but board members who are not on the executive committee want to attend. Under the Brown Act, those non-executive committee board members can only attend as observers. They cannot discuss, deliberate, or take action. Now, what we attorneys used to note is that given the spirit of the Brown Act, board members should avoid discussing NC business with one another on social media as well, to avoid this problem of having unintended meetings. Well, new provisions became effective by the state legislature in January of this year, which makes much of our prior advice law. So next slide, please. So a board member cannot directly respond regarding a matter that is within the jurisdiction of the body that is made, posted, or shared by any other member of the body. Note the restriction, that's very restrictive. So we'll read the second point very carefully. The prohibition applies even if only responding to one member and not to a majority of the members of the body. Therefore, under this new social media restriction, it does not matter whether you are only commenting, sharing with only one other board member about NC business. Responding to only one board member about an NC matter is a violation under the Brown Act. What constitutes problematic discussion? Well, according to the Brown Act for internet-based media platforms, which is sort of the definition and language it uses, responding to another member's social media post includes commenting, of course, but also sharing, retweeting, or liking or disliking a post, including with the use of emojis. So this can involve just even a thumbs up, thumbs down, retweeting another board member's social media post about NC business can be a violation of the Brown Act. We spent a couple of slides now talking about the Brown Act's definition of the meeting and the prohibitions that are embedded in there. But what does the Brown Act require for a meeting? Specifically, what type of notice must be made to the public? Next slide, please. Under the Brown Act, written agendas must list a general description of all items that will be discussed or acted upon by your neighborhood council. Note, the description need not be long. In fact, the Brown Act says something like 20 words, but it should be accurate. When reviewing an agenda item, one should consider, does the description of this item give enough information so that a member of the public will know enough to consider whether or not they should attend? Does it provide enough information for that member of the public to decide whether or not to provide public comment? This is very much a civic engagement and just, open meeting issue. Physical posting. The physical posting requirement has not changed since before the pandemic, and that's something that we want to emphasize. Therefore, the NCs have continued to physically post their agendas at a location that's accessible to the public 24 hours, 7 days a week, even though they're holding virtual meetings. And as you know, regular meetings must be posted at least 72 hours before the meeting. For special meetings must be posted at least 24 hours before the meeting. Now, for online and ENS submission, this is required by BONC policy. There is some confusion about whether the Brown Act requires website posting. The answer is yes, in the Brown Act, there is such a requirement, but that requirement section does not apply to the category of legislative bodies that neighborhood councils fall under. So in other words, that requirement is within the Brown Act, but if you read very carefully and closely, it does not apply to the type of legislative body that neighborhood councils fall under. However, there is a BONC policy. That BONC policy requires that agendas be submitted via email to ENS at least 72 hours or 24 hours in the case of special meeting. And as you know from your personal experiences with the NCs, sometimes there is a lag, perhaps due to a weekend, where the submission occurs timely, but the posting occurs later due to the lag of the weekend. Next slide, please. So the Brown Act not only requires proper notice of what will be discussed at a meeting, but the other aspect of the Brown Act is it requires opportunities for public participation by way of public comment. The Brown Act requires an opportunity for the public to speak on agenda items, but also the opportunity to speak on any item not on the agenda that is within the subject matter jurisdiction of the neighborhood council. So one thing to emphasize here is the board members are still subject to the agenda. They can discuss the items that are on the agenda. But unlike board members, members of the public can speak on non-agenda items that are within the subject matter jurisdiction of the neighborhood council. So the agenda restricts what the board members can speak to in a way that it doesn't with respect to the public. Now, neighborhood councils may also adopt reasonable regulations or rules on public comment, including time limits. When a neighborhood council wishes to adopt such regulations, whether in their agendas or in their standing rules, it's important to consult with the neighborhood empowerment advocate and rely on some of their experience. And to the extent that there are any legal issues or practical reasons or feasibility issues, it's really important to get a second look before passing any such regulations. The reason why is that there are other legal and practical considerations to think about before passing a regulation that's attempting to limit or regulate public comment. Next slide, please. For example, expressions of support or opposition constitute protected speech. Members of the public are allowed to record meetings if not disruptive. So obviously a regulation that said they weren't allowed to record the meetings would be contrary to the Brown Act. The public can criticize acts or omissions of the neighborhood council. They can criticize policies, procedures, programs, or services. So those are things that even if you try to regulate would be impermissible under the Brown Act. It's also just important to be prepared to handle disruptions in advance. We always advise not to be too reactive to a disruption at the time of the meeting. Rather, plan ahead, again, consulting with your neighborhood empowerment advocate who has experience not only with your neighborhood council, but other neighborhood councils, and has access to wealth of knowledge from their peers, can also escalate legal issues to us, is a really good way to start thinking about how you want to handle disruptive behavior. And then, as many of you know, last year in March and June, the governor issued executive orders to suspend the onerous requirements for teleconferencing that were and still are in the Brown Act. The requirements are so onerous, it was nearly infeasible to hold meetings via phone or online. The state legislature, through the pandemic, began the process of proposing bills to allow for virtual meetings in some capacity. What passed on September 16th, now this is just last week, was Assembly Bill 361. Next slide. That law, plus an executive order that was issued in September 20th by the governor, suspends the application of AB 361 until September 30th. But starting October 1st, AB 361 kicks into effect. And we're going to give you a little bit of information here during this seminar. And hopefully there'll be additional information provided by neighborhood empowerment advocates, the department, and or BONC going forward. Per AB 361, virtual meetings can occur during a governor proclaimed state of emergency. So this is not just the pandemic of 2020, 2021, but theoretically, before the law repeals in 2024, if there is another type of state of emergency that the governor proclaims, there is a provision now to allow for virtual meetings rather than having a series of executive orders. In the neighborhood council system, a BONC resolution was passed in June to continue virtual meetings through December. So that's important to keep into context. What's still under evaluation now is to continue virtual meetings going forward. In this case, BONC may issue findings for neighborhood councils pursuant to what AB 361 requires. Next slide, please. The Brown Act has also been amended to add or clarify restrictions about holding virtual meetings that differ to some extent with the executive order. For example, this new law accounts for disruptions of the broadcast of a meeting. So if there is a disruption that prevents an NC from broadcasting the meeting to the public, you would take no further action until public access is restored. So that would be a wait or a recess. Or if there's a disruption within the neighborhood council's control that prevents the public from offering comment, you take no further action. So for the first bullet point, for example, let's say for whatever reason, no one from the public can hear or see what is happening during the meeting, although the board can hear and speak with one another. That would be equivalent to an unauthorized closed session or a secret meeting because it's not being broadcast to the public. The public can no longer observe. So that's why a recess would be required. And that's whether it's the fault of some third party or whether it's the fault of the neighborhood council or technical issues. Now, the second bullet point is when there is a disruption within the neighborhood council's control that prevents the public from offering comment. For example, let's say that the host accidentally removed all the attendees or muted them so that they could not be heard. So again, that would be within the neighborhood council's control. So it needs to be remedied before the neighborhood council meeting can continue. Also, while the neighborhood councils have not done this, there were cities in California that were requiring that public comment be submitted in writing in advance of a virtual meeting. Now it's very clear in the Brown Act that you cannot require public comment be submitted in advance of a meeting. It needs to be real time. Now, also, what if a neighborhood council has listed the amount of time that it will take public comment? Well, it says timed public comment period must remain open until the time has elapsed. If, on the other hand, the neighborhood council does not have a time restriction for public comment, you must await a reasonable amount of time so that people can register, log in, and provide that public comment. Now, the department has been working on the impact of AB 361 as well as the city, as you can imagine, as well as cities throughout California. And we anticipate additional information moving forward. Note that some of the requirements on this slide may not change depending on how a neighborhood council has already been handling its virtual meetings. However, for other neighborhood councils, it may mean evaluation of the agendas and their way of conducting business. Now we've just got a couple more slides. Next slide, please. Meeting records. Members of the public have a right to review materials distributed to the board. Now, the board's obligation to provide those materials depends on when the materials were provided and by who distributed the materials. The question of whether a document should be linked to an agenda on the NC's website, this is all very fact specific. I would recommend, or please review the EVG protocols document on the department's website. There's a section on written and supporting materials, and it provides some scenarios so that you can understand, because it can depend on the circumstances. Finally, what happens if a neighbor council receives a complaint that it has violated the Brown Act? Let's go to the next slide. If you receive a Brown Act complaint, forward to your president and chair. Remember that the president and chair is the legal liaison for the neighborhood council. The president or chair should send the copy of the complaint to the Dunn representative, that's also known as the neighborhood empowerment advocate, and copy their assigned deputy city attorney. Board members should not respond to the Brown Act complaint until reviewed by the city attorney's office, and a deputy city attorney will assist with the response. There are timelines to respond, so please act promptly whenever you receive anything that appears to relate to a Brown Act violation. So thank you all. I'm turning this presentation back to Managing Deputy City Attorney Elise Rudin.
All right, everyone, I'm so sorry. We just haven't been given enough time for the depth of these issues. So let's go real quick. I'm going to give the briefest overview of California Public Records Act. The most important thing to know right now is that neighborhood councils are subject to the Public Records Act. Next slide. So again, just like the Brown Act, the purpose of the Public Records Act is transparency. So if you ever get confused, we are here to help. So are your NEAs from Dunn. But if you always remember that if you err on the side of transparency, at least you'll be in the right direction. Now, the only caveat I'm going to say is there are some items that need to be omitted from turning over from the documents you may turn over for privacy reasons or other types of exemptions under the code. So please do not send the documents without first checking with the city attorney and your NEA. Next slide, please. So just look at the request. And then also please let the NEA know, and the NEA will work with us as well as probably a president to try to get the request to the requester. Next slide, please. So the compile, review, redact, that will be with the assistance of the city attorney. Now, just know that under the Public Records Act, you're just required to respond within 10 days of the date that you receive the request. And the request does not have to be in writing. It can be done orally at a meeting. And also the requester does not have to say who they are, because I often hear, oh, well, they didn't put it in writing or they didn't say who they were, but they don't have to. The 10-day response doesn't always have to be the documents, depending on the size of the documents that might be responsive to the request. You can have additional time, but again, check with the NEA and city attorney. Next slide. I think that's the last. So it's not the last slide. So remember, the president or your chair is going to be responsible for providing the response. Please do not directly send the document to the requester, because there's a few more steps that need to be done before they go out. All NC board members, and I want to emphasize this, are required to do a search and produce documents if they have them. Simply not refusing to present documents is not acceptable and can lead to liability issues and other types of actions that might be taken. Either it might implicate your board or the board member. And again, your neighborhood empowerment advocate and our office are available to try to walk you through the process and work with the chair. Next slide. So one last thing I just want to emphasize, and then we have to really, really run. Please try to keep your personal emails separate from your business, your official neighborhood council business. I recommend having a dedicated email for your neighborhood council business. And text messages are also, by the way, included in those requests. If you're texting at a meeting or something like that, and it involves board business, please be aware that those texts could be the subject of a public records request. So I really highly recommend, if you really, the big points here are work with your president will work with us. You have to be responsive if you have the documents. We will make the determination. Your president will work with them to determine what should be turned over and what should not. And to please know that it's really a good idea to keep your personal matters separate from your role as a board member or committee member with the neighborhood council. Next. Okay, Steve's going to go over conflict of interest. I'm really sorry for how short this is. Steve?
Hi, everybody. So because we want to leave time for questions, I'm just going to be very, very brief. I don't even think we're going to run through all of the slides here. I think the slides will be available regardless after we're done. But just from a very, very general standpoint, conflicts of interests, it's a very complicated. It's going to require a detailed conversation with the board member and our office. But there are three main bodies of laws, and they're listed here. Political Reform Act, which basically relates to a board member's financial interests in the government decisions. And then the second category is Government Code Section 1090, and that relates to financial interest in contracts. And most of the time, it's going to be related to neighborhood purpose grants or NPGs with neighborhood councils. Keep in mind that that does implicate 1090. And then we have a last category called common law, which basically covers even non-financial interests. And it just applies to situations where board members are very personally involved in the subject of the government decision. So most important thing for you all to know is if you have any concern whatsoever that you or a spouse or a dependent child, someone in your immediate family might have some financial interest or personal interest in the matter before your board, reach out to our office as far in advance of the meeting at which the item will be heard so that we can give you advice, and we'll walk through it with you to advise you if we think there is a conflict and how to proceed from there. It could result in us recommending that you recuse, which means basically not participating at all in the meeting related to the matter, but it will require a detailed conversation with our office. I think I'm going to leave it there so that we have time for some questions. So Vanessa, you could kind of flip through the remainder to the until we end up at the last slide, which is for questions. And I think we'll go from there.
All right, thank you, everyone. So I do see a series of just questions that we have. Excuse me, that's my alarm, the 5-minute mark. I'm going to do my best to select some, and if city attorneys, if you see any questions that you think kind of stand out, please interrupt me. One of the ones that I see is, can a wrong Zoom number ID listed on the NC agenda, is it a Brown Act violation? Or if, say, the 3 ID numbers listed, but 2 are incorrect?
I'll take it first, and someone can chime in. The answer to that question would be, it depends. It really depends if there are other means to try to enter that the meeting and they are listed on the agenda. Some wrong information in and of itself is not necessarily going to violate the Brown Act. It really is a case by case, and it depends on whether or not that meeting can be accessed by other means. Ruth or Steve, if you want to chime in on that at all.
Okay. Hello? Yes.
Yes, I would agree with that. Unfortunately, it does depend, and we work, on a case-by-case basis whenever this issue arises. So it wouldn't be the first time we've had to address it. I think that there were some questions generally about our protocol. So the way I thought I might answer that, which is the way it works for us, and it's sort of time immemorial is that the neighborhood council president or chair is the legal liaison for the neighborhood council. So when there are questions that arise related to the neighbor council that are legal in nature, we field those questions through the neighborhood empowerment advocate or the president or chair. The only exception is when there's a conflicts question or a bias question, which Steve, Steve's presentation addressed. And in that situation, the individual neighbor council board member can reach out to us in advance about a prospective decision and seek some advice about how they might handle a situation for themselves. So that I think addresses some of the concerns here. And there was also
I want to, Ruth, I'm sorry, I just want to add one thing to that, piggyback.
Sure, go ahead.
There was a question that I saw, what happens if the board is having problems with a president?
Yes.
It's the president that's not abiding. At that point, I would recommend talking to your NEA and discussing it directly with them, and that they can, they're great at problem solving, and they can take it from there and analyze the situation. Vanessa, any other questions that aren't specific to NCs, just in general?
I did want to point out, this is Steve, like there's a question from Karen Waters about a conflict related to being a volunteer and an MPG. This is a perfect example of it really depends. In rather than trying to decide for yourself, you should reach out for advice. It's in the area of conflicts. It's just better to reach out and get our input on an issue like this.
Okay. All right, I do see one on time limits. So Melissa says that their board is currently discussing what is reasonable time limit for public comments on agendized and non-agendized items. Do you have any thoughts of what reasonable could be?
Well, the only thing I want to say, just know that the Brown Act does not set a time. So reasonable, and we usually give advice not to allow, depending on the meeting. And sometimes there's going to be a meeting where there's so many people that it's going to depend. But in general, and Steve, I would say at least 1 minute is probably reasonable.
And then keep in mind that it's both an opportunity to speak on agenda items as well as an opportunity to speak on items not on the agenda. So it's important to keep a bunch of different Brown Act concerns in mind when creating your agenda. And again, I would say that I've seen a variety of neighborhood council agendas, some with timed public comments, some without, some with different time limits. And it's really important to, work with your NEA and the neighborhood council advice division attorney to have an agenda that you're comfortable with, at least a template, not only with these items, timing, but also the reasonable regulations or notice that you want to provide to the public about how you will conduct your meetings.
And also, just know that when we're saying other types of comment, there's a general public comment too. It doesn't have to necessarily be to a agenda item. But special meetings don't have to have it, but we recommend, well, you could have general public comment anyway. It's always good to allow people to participate. I think that, I don't know if we're out of time here. Vanessa, is there a way that we can preserve some of these chat questions so we could maybe know how to address them in a different format or at a different time?
Yes, thank you for that. Yes, we are out of time. It's 11:40 a.m. and I want to make sure to give everyone enough time to get to your next session. And yes, this session is being recorded. I saw a couple of people comment that in the chat. So it is being recorded. It will be made available, I believe, through the planning committee, which they'll kind of communicate to everyone that attended how you can access the recording at a future date. I believe the chat feature is also being recorded or transcribed, and that may be available, or we'll keep track of that to make sure to review and get you the answers that you need. If for any reason we don't get to you, and I'm sorry, there were a lot of very good questions, feel free to email your NEA, your Neighborhood Empowerment Advocate, with your questions so we can make sure to follow up and get you the answers that you need. So with that, I'd like to just go ahead and ask for just a round of applause. I know we can't see each other, but for our presenters today, thank you so much for being here with us.
Vanessa, can I just say one thing to everybody?
Go ahead.
We do not expect you to absorb all of this. This was really, really a truncated version. So even if it just causes you to kind of think about it, that's really what the purpose of today was. So please don't be frustrated. The time limit, we don't expect you to have absorbed all of this.
Yeah, and thank you. That leads me exactly into in the chat for everyone. I went ahead and I added sort of a closing message that includes a 5-question workshop survey. Again, I think this, if you were here for the opening session, if you fill out one of these survey evaluations, you'll be entered to win a raffle. But most importantly, you know, the raffle's fun, but also we want to get your feedback as to, you know, how this workshop was run. Is there any suggestions that you have about how we can improve it in the future? That's kind of where you want to include that information too. So with that, I just want to thank everyone for coming, for joining us. Our panelists, thank you very much. And, you know, enjoy the rest of the day. And this room will be closing in about 30 seconds.
Thank you, Vanessa. We want to thank you too. Thank you for all your help.
Welcome.